So today this event will be a first of its kind. The event will show the value of intellectual property, not only as protection, but as a very rare but precious asset or creative and innovative professionals that will therefore help the economy. In our first segment today, we have Dr. Andreas Guadamuz from the University of Sussex, who is an expert in copyright, AI, and all other forms of IP. Dr. Guadamuz will take intellectual property from just knowing it as a form of protection to showing it as something that is around us every day without us even recognizing. To further this discussion on the intellectual property as it relates to business perspectives, the protection or the way how to secure income and inventions for various creators and innovators, I'd like to introduce our featured speaker, who will take a deep dive into intellectual property as the key ingredient to creation innovation. And as we know, Dr. Guadamuz is an international consultant for WIPO and has introduced the senior lecturer at the University of Sussex. I'd like to hand over to Dr. Andreas Guadamuz.
Thanks. Let's see. Thank you very much for the very kind introduction. I'm going to share my screen. It worked earlier, so hopefully it's going to work now. First things first. Sorry, you're going to see something. All right. Can you see the screen? I'm going to try to put the chat as well. Excellent. Thanks very much, first of all, for the very kind invitation. I am absolutely honored to be here with you, even if it is virtually. I have to start with a bit of an apology. I always like to start my presentations with an apology, but today the apology is probably more needed. I unfortunately tested positive for COVID on Saturday. So my voice is going to be a little bit weak. I'm feeling fine. It's evidence that the vaccines work. Sorry to make that point. I've only had a mild cold, but I am a little bit under the weather. So I apologize for that in advance. Even though I'm feeling quite well. The other part of the apology is that this first part of the presentation is going to be very general. There's no nice way of saying this, but because in general, in the sense that I want to set the stage of what intellectual property and what is important about intellectual property. Hopefully we'll manage to do that in a short time. While I want to do this briefly, because for the second part, whenever we're going to go into the second panel talking about NFTs, I'm going to run out of time. And there is no way I'm going to manage to do NFTs in the allocated time, but hopefully we'll manage both. So this is going to be more of a general introduction about the understanding of what we mean by intellectual property. By the way, I've put the Wordle image on purpose. Wordle is a very interesting case example of a story of a success, global success. I don't know if anyone else is as obsessed with Wordle as me. I've been obsessed. Today I got a score of 2, which I'm very proud of. But the interesting thing is that the person that generated or created the game did not protect any of the intellectual property. So the Wordle name is already been used by other people. There is not a trademark. And it's someone that has created a runaway success without actually even thinking or maybe thinking ahead that there was going to be such a success. And now probably eventually there will be a monetization because everyone has very good will towards this person, but it's almost not protected by any type of intellectual property. There is no trademark, there is no anyone can create their own versions. So interesting example. So I just wanted to start with that. As I was saying, I'm going to have a very broad introduction to what is intellectual property. And obviously, from the name, we are talking about the property of intellectual creations, as the name implies. This means that what we're protecting, we are protecting things that are the creations of the mind: literature, art, music, but also inventions, innovations, reputation of brands, the innovation that goes into a design. All of these things are going to be protected or fall under the umbrella of intellectual property. And that is one of the powers that it has. Of course, there are different types of intellectual property, and in the next presentations, you're going to hear more about the different types, but just to set the stage for now. There are very different types of intellectual property. We have the three main ones generally that are understood as copyright, patents, and trademarks, but then we have designs, also known as design patents in some jurisdictions, or industrial designs in others. Also, things like confidential information and trade secrets that are where companies are going to try to keep some of their know-how secret by not disseminating it. You can also have protection of things that you have not disclosed. You can have things like plant varieties, geographical indications, and even databases. And of course, with each one of these things, each one of the types of intellectual property, you're trying to achieve something. So to give you an idea, what you're trying is to promote the arts, then you are going to use copyright. If you want to reward investments, you are going to use patents. If you want to protect your reputation or brand reputation, you're going to use trademarks. And if what you want is to protect the distinctiveness or something that is distinctive, then you're going to use the signs. And if you want to use, for example, the protection of a region's produce, like champagne or cheese or milk or some wines, some types of coffee, then you use something that is known as geographical indications. Now, all of these are very general, of course. We're going to see them in more detail later. Now, obviously, all these types of intellectual property have different, because they are trying to achieve different objectives, they are all going to have different types of protection. So there is difference in the type of rights that you are given. There is a difference in the strength of the rights. Patents are much stronger but shorter because they act as a monopoly. You're protecting inventions. Trademarks last for as long as you have a reputation. There are trademarks that are over 100 years old because they're from companies that still have a reputation. And then you have things that copyright that are protected by lifetime of the author plus 70, 50 years, depending on the jurisdiction. So you have all of these different types of protection that are going to be strong in different ways because they're going to try to achieve different means. But generally, the reason why we have intellectual property is, well, obviously there are various reasons. One of them is perhaps one of the better known is that we are trying to incentivize creativity. We want people to share their ideas. And one of the ways in which we can do that is by giving people some form of rights. And then we can also have a reward for those who create new things. I create something, a society wants to reward this person for what they have created. We want to encourage, but also we want to reward, to reward those people. It also acts in many ways as a social contract. The social contract that society has, particularly with inventors, but in general with property creators, is that society will give this author or inventor a property right, usually an exclusive right and sometimes a monopoly right, in exchange for them sharing their work. And this is a very important part of the social contract. We want to encourage innovation, but we also want, this is very important, we want to take part, we want society to take part of those things whenever they run out of patents or copyright. So we are, particularly, I'm going to concentrate a little bit on the creative industries as an example of how intellectual property can encourage this type of innovation and creativity, specifically in the creative industries. It is, however, intellectual property is embedded in all of the industries. It's embedded in the pharmaceutical industry, is embedded in many other types of industries, but particularly with the creative industries is a very big importance. This is going to be part of what we're going to talk later when we're going to deal with things like NFTs. One of the things that I want to stress, perhaps, is that technology informs legal change, particularly with copyright. Technology is a driving vehicle for copyright reform. Any new types of works are going to be added to subject matter all the time. So, for example, when copyright was created back in the 18th century, it was created as a response to the printing press. Of course, the printing press predates that for a few years, but now we have a publishing industry. Now, what we have then is that the law needs to respond to this and create a system that encourages that dissemination of information. So first we have that. For many years, it was only about printing. Then we start to see new innovations in technologies that we now consider a little bit trite or a little bit basic, but imagine a world in which you have the first things like pianolas, where people can actually make music and make copies of music. It may have seemed like magic for some people. Then we start seeing photography, then phonograms, then film, radio and television, and cable. And every time that the technology is going to change, the law, particularly intellectual property, but specifically copyright, has to respond to those changes. So we're going to start seeing the law saying, okay, we have this new technology, we have pianolas, we can reproduce music. We have phonograms. We can now reproduce music in really impressive ways. We need ways of protection or ensuring that protection to ensure the reward that we want to give to the innovators and to the creators. And the same thing happens with all of the technologies that we have had to make those changes. All right. So technology brings forward change, change in the law. Everything, however, changes with the creation of the internet. What do I mean by that? Before, things like certain types of intellectual property, particularly things like copyright, were actually sort of niche systems, niche ideas, in which we are going to have very, for example, to create a copy of something. For those of you who are older, you will remember that to copy music, it was very difficult. You had tape. If you're of a certain generation, you'll remember listening to the radio with a tape recorder, trying to listen to a song. So copying was difficult. Analog copying was imperfect. Even photocopies to photocopy a book was imperfect. If you had a bad photocopier, you would not be able to create a good copy. So the only barriers are technological, internet speed, storage space, device capacity. But now things can be copied perfectly. So that is going to be one big change. Everyone nowadays can be an author, a publisher, a distributor, and a producer. So the barrier to entry into the creative industries, particularly, is going to be much smaller in many ways. I'm talking specifically about copyright industries and creative industries. So what we're going to talk about mostly in the later parts is about the future of creativity. What the history is over, and what we have now is a very bright future that we are seeing a monumental change in the creative industries, but also in other industries. Uh, we start seeing innovation in artificial intelligence, in patents, but in the creative industries, we start seeing the rise of user-generated content in which nowadays things like Twitch, things like social media, TikTok, and even other types of social media like things like YouTube, Instagram are creating a new wave of creators that do not rely on the same intermediaries as before. They have a more direct path towards the users and the market. So that is a very, very, very big change that we have to start thinking about from a regulatory perspective. So then we have the rise of esports. And that sometimes some types of esports go, the price in things like Dota 2 tournaments is higher than most tennis tournaments, to give you an idea. Then we start having the rise of artificial intelligence in the creative industries, where we see more and more things that are going to be generated with a machine. And this is another very big topic. Then we start having the rise of what is now understood as the metaverse. I am a bit skeptical about this because I think that the metaverse has been in existence for a long time. We used to call them virtual worlds or gaming. Some things like Second Life have been around for a long time. So it depends on your definition that is going to be met. Then we have the rise of blockchain NFTs, what is sometimes called the Web3 revolution. We're going to talk about that in the second panel in more detail. So I wanted to finish with a couple of ideas of how intellectual property can help, particularly thinking about all of these technological changes. So I've told you that all these changes, all of these technological changes are probably going to have to prompt a change in the law, or at least a regulatory response. So how does intellectual property keep pace with all of these changes, all of these blockchains and NFTs and artificial intelligence and all these things that are happening? How is it possible that we can keep track of all these changes? So I like this phrase that I've heard before: regulators are archaeologists, not detectives. I wish this was my phrase. It's not. I have no idea who said it, but it's very true. Regulators are very bad at proactive changes. So we have to see what's happening to respond. And so maybe there's no need to change the law just yet. Just use whatever is already here. So to give you an idea, there was a very early case dealing with the internet back in 1996. There were a few other cases, but this is probably one of the first historical cases. This is a Scottish case that dealt with the internet when we didn't have a lot of definitions. There were not a lot of technical definitions. There were not a lot of, well, lots of technical definitions, but not legal definitions. And the Court of Session had to ask a very obscure case involving copyright infringement of headlines. Container hyperlinks is not important. What was interesting was that because the internet had not been defined, had a legal definition, there was a bit of a danger that judges would just go and say, okay, what are we going to do? How are we going to manage with this new technology? The solution was very interesting. Lord Hamilton smartly declared that the internet was a cable program service. So for a few years, the internet was a cable program. It's a fascinating, fantastic solution. Now, you may be wondering, why am I using this? Because this has been repeated all the time. Sometimes we have lots of new developments, not only technological, but sometimes societal changes that require new approaches from intellectual property. So we're going to have computer games, dances, performances, folklore, traditional expressions. All of these can be technological but also societal that are going to require a change in the law or new approaches on how to think about intellectual property protection. And this is where I want to finish with this thought that is going to be explored later as well. For example, how can you protect a nation's creativity? Are there already tools? Well, there is no such thing, for example, as a protection of carnival. There is no copyright on carnivals or on traditional expressions. But maybe we can start looking, taking a page from the book of technological change to see how we can look at protection of intellectual property, of all of this creativity that is out there, and we can use all these tools for protection. So maybe things like performers' rights, passing off, which is a tort in many common law systems. Maybe use designs, trademarks, push for traditional knowledge and folklore international protection. That is something that the country can do. Things like unjustified enrichment, and maybe even the use of contracts. I am a big believer on contracts. When in doubt, you can release a contract. So with that very, very broad introduction to the subject, I give back the word to you, and I'll be delighted to talk about NFTs a little bit later. Thanks very much.